Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
How do courts and trademark offices decide whether two trademarks are too close for comfort? The answer lies in what lawyers call the likelihood of confusion. This concept is at the heart of trademark law because it protects consumers from being misled and businesses from having their brand identity diluted. In practice, likelihood of confusion means that people in the marketplace can't easily tell two trademarks apart. If buyers mistakenly believe that a product or service comes from a company when in fact it doesn't, the law steps in. That mistake can take different forms. Sometimes it's direct confusion, where people simply think two products come from the same source. Other times it's reverse confusion, where a bigger, well-known company's mark overshadows a smaller one, making the public believe the smaller firm's goods are connected to the larger brand. There's also initial interest confusion, when a similar name or logo draws in customers at first glance, even if they later realize the difference. And in industries like fashion, there's post-sale confusion, where bystanders assume a copy is the real thing, damaging the reputation of the genuine brand. When courts assess these cases, they don't just hold up two logos and see if they look alike. It's a much more layered evaluation. The first factor is, of course, similarity. That includes how the marks look, how they sound, and even what they mean. A word in another language can sometimes be confusingly similar if it creates the same commercial impression. What really matters is the overall impact on the average consumer. The second factor is the relationship between the goods or services. Two identical names can coexist if one is for bicycles and the other for insurance. But if the products are complementary or sold to the same audience through the same channels, even less similar marks can raise red flags. Another critical factor is the strength of the earlier mark. Arbitrary or fanciful names like Apple for computers or Clorox for bleach are considered strong and get broad protection. Descriptive names like Speedy Delivery are weaker unless they gain recognition through long use. And if a word becomes generic, like escalator, trademark rights can be lost altogether. Famous brands, however, enjoy especially wide protection because consumers tend to connect them with their owners regardless of the industry. Courts and trademark offices also look at evidence of actual confusion. Even a handful of mistaken purchases or inquiries can strongly suggest a real problem. Market context plays a role too. How close the businesses operate, what industry practices are common, and where the marks are used geographically. Artificial intelligence is changing how this evaluation is done. Today, AI tools scan millions of trademarks, logos, and online mentions to detect similarities that humans might overlook. They can even predict potential conflicts across languages and regions. But AI also introduces challenges. Systems that generate logos or brand names sometimes produce marks that look or sound a lot like existing ones, blurring originality and potentially creating new disputes. And because consumer perception is often subtle and cultural, AI alone can't fully capture the nuances. This analysis isn't theoretical. It arises at every stage of a trademark's life. Before filing an application, companies are advised to run clearance searches to avoid conflicts. During examination, some offices, like the U.S. Patent and Trademark Office, check for similar marks. Others, such as the EU Intellectual Property Office, leave it to existing owners to object. If a conflict is found, opposition proceedings or even cancellation actions can follow. And of course, if infringement happens in the marketplace, lawsuits may be the last resort. So, what can businesses do to stay safe? The best strategy is proactive. Start with a comprehensive search, not just for identical names, but for sound-alikes, look-alikes, and even similar concepts. Invest in continuous monitoring. Today's tools can track domain names, e-commerce platforms, and social media in real time. Work with experienced trademark lawyers. Set clear rules for how your brand is used and, where necessary, consider coexistence agreements to avoid clashes. Sometimes the smartest move is simply to rebrand before problems escalate. Ultimately, the likelihood of confusion is a moving target. It depends on consumer perception, business context, and legal standards that evolve over time. But one thing is constant. Safeguarding a brand requires vigilance, In a world shaped by digital transformation and artificial intelligence, businesses that actively monitor, adapt, and enforce their rights will be the ones that preserve brand integrity and maintain their competitive edge.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.